Good evening. I'm Joanna Toch. I'm a barrister. I have a business called Family Law Cafe, and the intention of that business is that you can use us, you can come to us to provide everything you need for your family law matter, including strategy, getting all the experts you need, keeping your documents in a secure place, and just overall running the case in the best way possible. I'm a firm believer that everyone should have access to justice at their own level, at a price you can afford. Of course, you can't always afford a lawyer, but there are some things that you need to use a lawyer for. If there are assets or there are issues about children, then it's likely you're going to need a lawyer, and you're going to save money and get the best value by doing so. We're trained to do the job, and I think often people are worried about using a lawyer and about the costs, and I totally and utterly understand that. But my motive for setting this up was people would be empowered to have the knowledge, make the decisions, be supported and get the best outcome. It would be perfect, wouldn't it, if we never had to litigate about family law. That would be a perfect world, but the world isn't perfect. So if you have a family law problem, come and talk to us, and we'll do the best that we can to help you. Okay, tonight's subject is what happens in a financial remedy final hearing. And I was talking at my last Tea Time Live about Children Act or children final hearings, and the reason that I thought it's useful to talk about final hearings, including financial remedy final hearings, is because you don't get to sit and watch them. I know that we're seeing some family litigation on YouTube or on the TV, probably not the most typical family litigation, and not the sort of litigation you'll be involved in if you ever are. But you just can't wander down and go into a family court, even though they're trying to make it more transparent, because of course, if it was your case, you wouldn't want just, you know, the neighbours from down the street just wandering in and say, oh, we'd like to watch this bit of litigation about your assets or about your children. So that's why family cases are private. But of course, there is a push towards transparency and allowing them to be reported. Doesn't mean to say you can go in and watch a family case. So I thought it would be informative to give you some understanding of how a family law case, a financial remedy final hearing would happen, how it would go, and so that you'll know, if you're heading that way, what you're likely to expect, and it can just help you. Probably would make you feel a little bit calmer. I certainly know I work like that. If I know what's happening, I can prepare the best I can, whereas I just hate going into anything unknown. That's my idea of a horror show. So if you're like me and you like to have as much knowledge as you can, then that would help. It says, why you don't read the comments? Oh, I'm sorry if I haven't. I've probably explained before that I do these live and I want your comments, so please put them in. So repeat your comments if I haven't answered them as I go along. Definitely want to hear your comments. Sometimes I'm just thinking about what I'm saying rather than reading as well. Probably explained before, I like to just do one thing at a time. So this is a challenge for me, particularly as I've got my glasses on, and that wowould be there. So someone wants to be in my video. I'm not going to join, I don't join people live. I just make the request before. Always happy to have people on my live video to come on, but you just got to ask in advance. Again, as I say, I really like to be planned and organised, and I think you'll get the best value if you make the request in advance. Okay, so final remedy hearings, here's how they go. If it's got to the stage where there is a final hearing, then there are obviously serious issues of disagreement between the parties, because the court process in financial remedy is all designed to try to make you settle if you possibly can, even to the extent that there will be in 99.9% of cases, what's called a financial dispute resolution appointment, where a judge rolls his or her sleeves up and gets involved and says, this is what I would do if it was a final hearing. And that's a really big incentive or assistance to help you settle, because you're actually getting a judge who says, this is what I would do in the case. So a lot of cases settle at that stage. If they don't settle, then there's clearly issues between the parties. Serious issues need to be heard. And what would happen before that final hearing, send a request to be in your live video. I don't take requests as I'm going along, so you can put your comments there, but I'm not going to join anyone on this video. I'm just going to talk to you about what I plan to talk about. So if you're in a final hearing, a financial remedy, then it's really important, first of all, to get the paperwork absolutely spot on. And if your paperwork is poor, then don't expect to get a good result. And that means that you should, in my view, get a lawyer to act for you at a final hearing, because there is going to be a reason that you're there. And it would usually be because there's a dispute about, I don't know, it could be that one party wants 60% of the value of a property. It's quite a lot of money involved, and it is worth litigating about rather than, an equal sharing, because in financial remedy, the principles are needs, compensation and sharing, and there can be a needs argument that it shouldn't be a sharing case even after a long marriage. So the paperwork is going to, a really important part of the paperwork is to have an accurate schedule of the assets. And that means from all of the disclosure that there's been, there will be a schedule of assets. And the courts encourage parties to do joint schedules to try and agree them, because the first thing the judge is going to look at is what are the assets that are in dispute. And if the parties are in dispute about what the assets are, and that can be what are the marital assets or what are post-marital, premarital, even there could still be a dispute about the value of an asset even at a final hearing, then it's important that the schedule of assets sets out where the differences between the parties lie. So it's really important to be obeying court orders, getting your disclosure done on time, and that the schedule of assets is an accurate document, because the first thing the court's going to pick up. Courts also like to know what each party's position is and have a net effect schedule. What's going to be the outcome if you get the order you want? Really important the court can understand your case. You should also have an accurate chronology of the important events, and there should be an accurate case summary of what this case is about. And there will be a skeleton argument that you'll prepare on your side, and hopefully that is your lawyer. As I've said, this is specialised advocacy, and that document should be really clear in spelling out what the law is, why the facts in this case should be applied in a certain way, and really what it's about, where you're going and what your answer is to the other side's case. So those initial documents are going to be right at the start of the bundle. They have to be good, and that is why you need to be prepared. You can't just plunge into these hearings with no proper preparation. It needs to be all done way in advance. Now, on the day of the hearing, you're going to find, and I have this all the time when I do final hearings in financial remedy, you still get people trying to negotiate at the door, even though everything's prepped up for a final hearing. And sometimes people do settle at the court door, and that can be absolutely fine. Bit of a shame it didn't settle earlier, but there may be reasons for that. And so you may be there at court, in a room at court, and your lawyer is here and there and still negotiating, which may come as a little bit of a surprise, but they're not going to negotiate unless they think they're going to get a better outcome for you than being in the hearing. That's kind of how I see it. I wouldn't want to settle a case unless I felt that this was the best way. But it could also be the case that you can settle it just before at the court door, and it is everyone's happy, everyone's got what they want. and it just wasn't the case that could settle earlier. So it is possible that even just before you're going in, there's still a flurry of activity. What I'd say is something to remember. I really hate it if people just try and keep negotiating during the time when you should start. Of course, if you're really close to settlement and it's 10 in the morning, you should be starting at 10. Judge will give you a little bit more time, but you don't want to keep negotiating to 11:30 and you've lost the time that's so valuable for your hearing. So that's important. Right, when you get into court, let's say the case hasn't settled, you've got all your bundle has been done in advance, your paperwork's perfect. If you are the applicant, then your lawyer is going to open the case, and that's a key position to be in. They will explain to the judge what the case is about. Of course, as I've said, you're going to have really good documents. So hopefully it should be short, succinct, accurate, punchy, getting to the point. And often what judges do, although there isn't a right of opening for the respondent, judges will want to hear what the respondent's counsel or solicitor has to say in response to the opening. That's up to the judge. The judge runs the case and has the power of case management to run it effectively. And judge may have questions about at the beginning, and it is interactive. It's a civil case, so you have a judge who's dealing with both the law and the facts. And that's why the advocacy is different to if they were a judge and jury, for example. It's a different kind of way of presenting a case. So the opening has happened. We know what we're doing. The first witness will be called. Now, often in a financial remedy case, that's going to be simply, let's say it's the wife, and that you will be called the wife, which is really quite, it's not great to be called by a title. It'd be nice if they used your name. And I'm terribly sorry about this, but you're going to hear lawyers and the judge refer to you as the wife and the husband. It's just shorthand, and hopefully they will apologise and say to you, I'm terribly sorry, we are calling the wife the husband, because we are, as lawyers, we're kind of thinking about the facts. We're thinking about the numbers, the law, and there is a bit of depersonalisation, and I can appreciate that may be a little bit, may not make you feel that great, but it's done with the best of intents. So if you do find yourself being referred to as the wife, even if you've got divorced already, you might have had the decree absolute and you're still called the wife, and you think, well, I'm not the wife, am I? I've moved on. I'm afraid you're going to hear yourself referred to in that way. Let's say it's the application of the wife. She goes up to give her evidence. You can't take anything into the witness box, and you are then giving evidence on oath, and you will be asked beforehand, do you want to give it on oath or do you want to affirm? And clearly, depending on your religion, you'll let the usher know what your religion is in advance, and it's up to you. There's no difference whether you affirm if you're not religious or whether you give your evidence on oath in your particular religion. You must be speaking the truth, and that's what the oath, the affirmation, is about. And no one should move at all when you give the oath or affirmation. It's that important. No one moves, no one interrupts. You are giving a very solemn promise to the court to give your evidence truthfully. So you will give your evidence. You will start by your lawyer saying to you, taking you to you'll have done a statement. Pretty much, there's very few cases in which there isn't a statement. There's usually one lead statement, which is called a Section 25 statement. You will verify the truthfulness of that. You will verify the contents of your Form E and all your disclosure. And there might be replies to questionnaire. There might be 3, 4, 5, 6 documents in the bundle. You will verify the truth of that. And if there's any amendments, if anything's incorrect, you will make them then. And that means that all of that evidence goes in as your evidence. You don't need to repeat it orally. It's given in writing. You've already put it there. You've confirmed the truthfulness of it. And it may be, if the judge gives permission, you're asked just a few questions. You don't have the right to give evidence in chief. It's a civil case, you have no right, you can only do so by permission. But you might be asked a few questions, let's say, there's some extra property particulars have come in, and you might be asked about those and why those ones are particularly important. So you've given your evidence in chief. You will then be cross-examined by the lawyer for the other party, by, let's say, the husband here. The cross-examination should be directed to issues that are in dispute. So you may not need to be, we won't need to be asked questions where things are agreed. And let's say the biggest issue is your housing needs, that you say, I need a house for 650,000, I need then moving costs, etc., etc. You produce property particulars. And let's say the husband is saying, you can be housed sufficiently for 450,000. That's just a simple example. So there'll be questions about that, and if you are properly prepared, you will have discussed the sort of things that you really need to know about. Like, you should have gone to see these properties, viewed them if possible, because so you'll be able to answer, yes, I've viewed that property that he's put forward. It's highly inappropriate because, I know, there could be needles on the stairs as you go in. Unless you viewed it, you're not going to know the answer. So proper preparation for the sort of questions you'll be answered is really key, and you will answer truthfully. And you will use the questions as a way of giving effective evidence. You're not there to answer different questions. You're not there to avoid the question, and you'll listen carefully to the questions and give your answers looking at and directing them to the judge, and you'll give them clearly and at an appropriate speed so everyone can keep a record. And it's undoubtedly very nerve-wracking, and it's tough. It's tough. People don't want to be there in a witness box or the spotlight on them, I'm sure. But it's a civil case, not a criminal one. And most of the time, the issues will be about differences of views as to the appropriate settlement. Now, there could be a case where conduct is raised. So there could be questions asked of you about your conduct. And conduct is only going to be relevant if it has a financial effect. So you'll have to be prepared. And we as lawyers will know our case inside out. And if you're being untruthful, that will be exposed. And so be aware. I've been in many cases where through the case, it's, I think people think that because there is an urge to settle all the way through, that sometimes they can say things which are completely untrue. And it's just demonstrably untrue, that they're just talking nonsense, really. We've done it for a while. So that will be exposed. We will ask the questions and that will come out, and there will be a silence and people will be waiting for you to answer and give your evidence. And if you've been untruthful, you've not disclosed or something like that, expect that to come out and the judge to take a view. So you'll be cross-examined, and that could be for a couple of hours. It just depends on the case, doesn't it? How complex it is, how many issues there are. And then at the end of that, your own lawyer will re-examine you to clarify things, perhaps try and help you out, things that you haven't covered well. They might ask you a question in a way that it helps you explain something that they know that you haven't explained very well. And those re-examination questions must arise from questions from cross-examination. There could be, in your case, an expert that you're calling. Let's say, it's unusual, but let's say there is a difference in view about a property valuation. So I've been in cases where we've had experts, and we've had a couple of them. We've got permission to challenge the expert valuation. So we've had a different surveyor, and then they would be asked questions by each parties. There could be a witness in your case. Now that's really unusual, and it really depends on the circumstances. There could be an intervener. So it's the same procedure for their evidence. Once your case is complete, then if you're the applicant, then your lawyer is going to say that is the case for the applicant, and then it's the respondent's turn. And in the same way, the respondent will give evidence, your lawyer will be cross-examining the respondent. And a good thing to do when the lawyers are doing their stuff is just have a pen and paper, bring that in right from the beginning and keep some notes, because usually at the end of the cross-examination. I certainly do. I would turn around and say, is there anything else I haven't covered? And there could be something that you've made a note of, and it's just a lot easier if you're writing notes for your lawyer. You don't have to pass them through all the time, because it's really distracting if you're the lawyer when you're asking the questions, but keep them in a note, and then at the end of their period they will check with you, and is there anything else? And if it's written down, it's much easier to gather that information from you, and the judge will always give an opportunity for that. I should add, sorry, going quite fast, but after each witness has given evidence, the lawyer will always say to the judge, do you have any questions for this witness? And the judge may well have questions, and they're really important. Obviously, they will be... It's important to watch what they ask, that shows their way of thinking. And it is, sometimes it happens that a judge will intervene while you're giving your evidence. So that's the evidence part of it. And then after all the evidence has been given, then each side will give its closing submissions, and the respondent goes first and gives the response to the case, goes through all the points, and it's usually quite interactive when closing submissions are made. Certainly the cases I do, the judge will intervene and ask some questions. I mean, sometimes they won't, sometimes they'll just sit there and take all the notes and listen carefully, and then at the end have a few questions. It absolutely depends on the judge. And then the applicant's counsel or solicitor will make the closing submissions on behalf of the applicant, and then it's usually the case that the judge will need a little bit of time just thinking, going through things, and also a bit of time, go away and then come back and give a judgment. Sometimes it's a reserved judgment. Unfortunately, it does happen that you can be in a case, and even though you've given an accurate time estimate, or your lawyer's given an accurate time estimate, list officers just love to put in extra cases. There's a case that the judge has to deal with at the beginning of the day, so you start a bit late, and that sort of affects the time. And so it can be the case that all the evidence is given, and then a written judgment is handed down after. So that's my gallop through what happens at a final remedy hearing. I had some requests which I'm really grateful for to come on and have a chat with me. I'm going to have a look at those, and what I suggest is you write a direct message after this so that I have a chance to look at them, talk to other people at Family Law Cafe, and we always try and plan in advance what we're going to talk about. And just let's look through. I'm really grateful to see so many people joining me, and people saying yes, it's helpful. Lovely to see that. Seeing different people who've joined. Let's see if there's anything that I can help with. Yeah, I follow you from Iran. Well, I just want to say I'm talking about what happens in the UK. I have no specialism in Iranian law. Of course, we have in the UK pretty much a divorce capital of the world. And if you have assets in the UK, then you can probably litigate here. It just depends on your connections. But if you don't, then you won't be. Just going through the comments, see if any I can answer. Yeah, someone saying so helpful. That's lovely. Thank you so much. A request to be in live. Just so send any request to be in the live in a direct message, and then we can sort that out and publicise it in advance so people can see it, and that would be great. Let's do this live. Late to this live. Is this the FDR? Any comments on private FDR? Okay, I've been talking about the what happens in the final hearing. So I did touch on FDRs earlier in the chat, and what I'll do is I will have one just about FDRs. I think that would be really valuable. I hope it would be valuable. So I'll do a talk just about what happens in an FDR. So what I've been talking about today is when the FDR doesn't settle the case and it goes to a final hearing, which is pretty unusual, but it does happen. And I am going to add that I've seen the cases that go to a final hearing when parties haven't had representation. And I think if you're going to a final hearing and you've not had any representation, just think about getting, maybe a fixed fee assistance from a lawyer just to go through everything, just to see if there is a way to settle it, because it's such a shame for a case to go to a final hearing when it's a very difficult thing to do. It really is a specialised area. And so if you're heading for a final hearing and let's say neither side has been legally represented, I would suggest that you get some legal advice and then just put in a really detailed open offer and explain your position as fully as possible, just to see if it can be settled, because you're not going to get everything you want all of the time. Life isn't like that, and neither is litigation. And it's very harsh. A final hearing is not a bundle of fun. You're not going to just be having fun all the time through it. It's really serious, and you need to be utterly prepared. You need to be really clear in your objectives, and you need to make sure that you really have given all of your instructions to your lawyer and you do a really good job. And it's both sides are not going to win. That's just obvious, isn't it? So litigation is, don't litigate unless you clear that you have to, and sometimes you do. Sometimes you have to. In which case, if you do, make sure you really prepare well and it goes well. Okay, that's all I've got for you today. We'll definitely do a live on FDRs in future time. And if you want to join me and have a chat, then just send me a direct message and we'll get together. Thank you so much and have a great week. See you Wednesday. Bye.